This program was recorded on July 10th, 2015, on the main campus of Georgetown University, Washington, D.C.
James Madison, of course, means a lot to me. I teach constitutional law. In working on the Virginia Constitution, I recall that the first public action that I can recall James Madison taking part in was when he was a member of the Virginia Constitutional Convention in 1776, at which he was the one who proposed the language of free exercise of religion. He was 25 years old at that time, so it makes me, I don't want to think about what I was doing when I was 25. But that certainly wasn't helping write constitutions. Well, our topic today takes us a good deal further back. I mean, the Constitution itself, it's hard enough to get your hands around the 18th century, but this topic asks us to think a little bit about something that happened 800 years ago in the 13th century. Now, I've just come back from England. I was giving lectures over there, a little like carrying coals to Newcastle. You know, why would the English invite an American to come over and talk about Magna Carta? But it was simply marvelous to be there. It's, you know how every town where George Washington ever slept claims that honor, and every town in England that has any plausible connection, whatever, with Magna Carta has claimed a place in the sun. So it's really been quite a cottage industry on the other side of the Atlantic. Well, that's not surprising, but the question I want to pose to you this afternoon is, assuming they care about it over there, what's it to us? I mean, this is something that happened in 13th century England, a quarrel between King John and his barons, and you know, it was a long time ago and pretty far away, and why would Americans be concerned about Magna Carta? So I think part of my obligation this afternoon is to try to draw you a little bit into the picture in which I would argue, I won't try to make out the complete case for it, but I think I would argue that Magna Carta has actually had more influence on American constitutionalism than it had in the country of its birth. I'll try to spell that out a little bit for you. Now, in talking about Magna Carta, one talks about King John. He's always called Bad King John. So, the first time I didn't actually meet King John. I know I've been around for a while, but not quite that long. I was introduced in a manner of speaking to King John by A.E. Milne, you know, the creator of Winnie the Pooh. He grew up on A.E. Milne. He wrote a wonderful little book called Now We Are Six. Maybe some of you, I see a nodding head or two. Your childhood was deprived if you were not read Now We Are Six when you were a kid. But I remember reading this book or having it read to me, and one of the poems in there is called King John's Christmas. And it begins something like this. King John was not a good man. He had his many ways, and sometimes no one spoke to him for days and days and days. Well, you know, you're a little kid, and you read about someone who's being shunned, nobody will talk to him. That's a big deal for a kid. And I said, you know, nobody could be that bad. Well, I grew up and did some reading about King John. He was that bad. Maybe worse for that matter. So without him, we wouldn't have Magna Carta. But actually, think about the number of great moments in history, the great documents, such as the Declaration of Independence, that we wouldn't have had but for some bad actors, right? So King John has given us, in a sense, Magna Carta. Well, it begins at Runnymede in the 13th century. King John, he probably was, in a moral sense, a bad king, a bad man. He was certainly a rotten king. He did everything wrong. I mean, he was one of the most maladroit rulers in English history. It's no accident that there's never been a king named John since that John. There'll never be a John II on the throne of England. It's just the name has been tainted. Well, he quarreled with the church over the appointment of the Archbishop of Canterbury. Indeed, the Pope reached the point of being upset with John. He put England under interdict, that sacraments were not performed, like marriage and christening and burial and the rest. I mean, it's pretty serious stuff in the 13th century. John quarreled with the merchants of London. He quarreled with the French always because he wanted land that the French were claiming. And at the Battle of Bouvines in 1214, disastrous military campaign where John basically lost most of the land that remained to his, many of which were his barons' land in Normandy. So he was a bad military ruler. he quarreled with the barons. And that's the essence of what gave us Magna Carta, because as he was adventuring in France and other demands, it cost money. And so he needed money. The barons, he thought, ought to provide more than they were willing to provide. And so he would arbitrarily imprison people and, in general, just cross all the lines of injustice. And the barons finally had it with him, and it was basically civil war between John and the barons. Well, the city of London went over to the barons. The forces were collected against him, and finally, on June the 15th, 1215, they met at a place called Runnymede. It's a meadow about halfway between London and Windsor, kind of like no man's land, sort of like the demilitarized zone in Korea. And they met there because it was kind of nobody's territory. It was also marshy enough that knights couldn't ride in on horses and you couldn't be taken by surprise. So they met at Runnymede and they hammered out this agreement. It was really a peace treaty. In fact, it was a total disaster as a peace treaty because it didn't bring peace. But it produced a document not yet called Magna Carta. That name comes later. But they produced the document we now know as Magna Carta. Copies of it were made and, as I understand, meant to be sent out to all the counties in England. Several of those copies now still exist. Well, I'm not going to detail the medieval contents of Magna Carta. A lot of it has to do with, when the barons had to put up money to knight the king's oldest son or marry off his oldest daughter, all kinds of things like that. Interesting, but not relevant here. There are two provisions in Magna Carta that I think you want to know about in terms of beginning to think about how you get from Runnymede to American constitutionalism. And one of those provisions, they now call it Chapter 39, said that no one would be proceeded against save by the law of the land. Now, law of the land in time came to be synonymous with what we call due process of law. So if you want the early origins of the 5th and 14th Amendments, due process clauses, you can take it right back to Chapter 39 of Magna Carta. The other provision that I think is of modern interest is Chapter 40, and that was the one that said justice shall not be sold, delayed, or denied. Baseline principle in Anglo-American constitutionalism. So there's some other important provisions, but those alone earn the title of Magna Carta. One of the curious footnotes is that when you say the phrase Magna Carta, that means the Great Charter. And so you assume that means it's a big deal, right? It's the Magna Carta. It's very important. The fact is, a few years after its original issuance, the charter was reissued, and part of it was taken out, the charter of the forest, having to do with forest laws, and to distinguish that piece of it, which was a smaller part, from what was left, which was the bigger part, the bigger one was simply called Magna Carta, the big charter. Purely descriptive, but it's interesting how history has conferred upon that phrase a much more symbolic meaning than simply one connoting size. Well, that's where it all started. It would have ended there if it had been left up to King John. I mean, King John had no intention of keeping these promises. He didn't want them. He was an unwilling bargainer. He wanted out of that bargain. Indeed, he managed to induce the Pope only a few weeks later to annul the charter on the grounds that it had been an illegal contract because it was the product of duress. I mean, it's a simple principle of contract law. If you're forced into a contract, it's not a legal contract. So the Pope accepted that argument of King John. Well, that would have been the end of the matter, but King John died the next year, 1216, and one of the chroniclers says that King John died of a surfeit of cider and new peaches. So I don't know what's going to be on the refreshment table afterwards, but if they offer you cider and new peaches, I think I'd say no thanks. I think I'll pass on that one. So King John is dead. His successor, Henry III, is 9 years old. Now this is the Middle Ages. How long is a 9-year-old king going to live, right? He'll never see his majority. The long knives are probably out. I mean, you've seen Game of Thrones, you know all about this kind of thing. This was Game of Thrones season back then in England. So Henry III's advisors, his regent, William Marshall, and the other advisors hit on what I guess you'd call a public relations gimmick. They said, we got an idea. We will have Henry III reissue Magna Carta as a way of showing his being rooted in ancient constitutional principles, the ancient rights of the British people. So he issued, or it was reissued for him. When he reached his own majority in the 1220s, he then reissued Magna Carta in its own right. So that began a tradition in England of each successive monarch who came to the throne reissuing Magna Carta. So it really became very much part of the law of the land. Now there's one other thing that happened in the Middle Ages, and that was about 100 years after Magna Carta, Parliament passed a statute that said if any law were inconsistent with, in conflict with Magna Carta, it should be null and void. Now, I mean, that presents the sort of legal question of how could one act of Parliament trump another? You know, I mean, they're on the same level. It probably was, in effect, an instruction to judges, a sort of a canon of construction that if you found a law inconsistent with Magna Carta, you'd give preference to Magna Carta. But whatever it actually meant technically, excuse me, it began to be part of this notion that Magna Carta was not simply another law. It was a super statute. It was really better than ordinary laws. Well, that's the medieval story. I'm going to pass over Tudor times. I guess you'd have to say that Henry VIII isn't remembered. His reign is not remembered as a time of great constitutional principles. Anne Boleyn would not have said that, certainly. I mean, you've seen Wolf Hall, you know what the Tudor period was like, so I'm going to pass past that. Into the 17th century. Now, this is an important time on both sides of the Atlantic. I mean, if you're thinking from the American perspective, this is the century when the first English-speaking colonies are being planted, starting with Virginia in 1607, Massachusetts, and all the others. I was giving a lecture in Boston in the fall called the James Otis Lecture. And I found, John Adams has been mentioned already, I found my friends in New England are great at words, but there's something, they have some problem with numbers. They don't quite understand that 1607 is a lower number than 1620. If you're from New England, you know exactly what I'm talking about. So I had to turn tail and come back to Virginia. So 17th century, all these colonies are being planted in America, and if you know something about political and constitutional history in 17th century England, or just any kind of history, it had to be one of the most turbulent centuries ever. I mean, England went through the upheavals not unlike America during our Civil War. You began when the Stuarts came to the throne. James VI of Scotland became James I of England, and he brought with him a notion of divine right of kings. Now, divine right of kings is not a constitutional principle, but he thought it was. So that put him on a collision course with Parliament. And the leader of Parliament at that time, the intellectual legal leader, was Sir Edward Coke, the great commentator on Magna Carta, certainly the leading jurist of his time, Attorney General, President of the Court of King's Bench, but also the leader of Parliament resisting the pretensions of the Stuart kings. So that battle produced another one of the great English liberty documents, the so-called Petition of Right of 1628, which reinforces principles of Magna Carta. Now that didn't settle the quarrels, it went on. Finally, if you're familiar with this period, you'll recall that it reached the point of civil war, starting in 1642. That war was on and off again, and that led finally to the trial and execution of Charles I, 1649. Now that was momentous. That must have sent shockwaves through the crowned heads of Europe, the idea that you could, I mean, kings were killed, of course, on the battlefield or assassinated, but to be tried in a court of law and what purported to be a court of law and then executed was really something remarkable. That produced the Cromwellian period, Oliver Cromwell and the so-called Commonwealth, until finally the Stuarts were brought back in 1660. You would have thought that with the problems they had with the Stuarts in the early part of the century, they wouldn't bring them back again. That showed how bad things were. Charles II, James II, and to conclude that rather tumultuous period of constitutional development, it's in the 1680s that another round of confrontation between Parliament on the one hand and the Crown on the other led finally to what historians, I think, used to call the Glorious Revolution. I suspect that may not be, I don't know if that's the acceptable phrase anymore, because how glorious it was depending on which side of the battle you're on, I suppose. But at any rate, the Glorious Revolution gave us William and Mary, who were brought to the throne, and another great constitutional document, the English Bill of Rights of 1689. And that document, I hope, is something that surfaces during your reading and your study this summer. Good, I see a nodding head. You really want to study that both because of what it was really the foundation of the modern British system of government, but it's also, in American terms, influential. You can lay that English Bill of Rights side by side with our Constitution, and you can see direct crossovers of language that was lifted word for word from the English document into the text of the American Constitution or the American Bill of Rights. Phrases like cruel and unusual punishment, for example, come directly from the English Bill of Rights. So now I won't take the English story down to the present time. We might take that up in Q&A, but the 17th century is the crossover century. You've got on the English side what's emerging and becoming to look like something like the foundation of modern British government. And on the American side, you have these colonies, and what you find there is very interesting. Take, for example, the Virginia Company Charter of 1606. Most of it's about trade and commerce, and it was a stock company. You know, people were buying shares in it. They thought the Spaniards had brought all this gold back from the New World. They would get rich by investing in the Virginia Company. Well, I don't know if you have spent much time in Virginia, but the amount of gold that's been discovered down there is not going to make you very rich. They did finally discover tobacco, and that did make them rich. But in this Virginia charter, there was distinctive language which said that if you were an immigrant to the New World, you pulled up roots and left England and went to Virginia, you would enjoy the privileges, franchises, and immunities that you would have enjoyed in the mother country. Now, I think that's distinctive to the English colonies. You would not have found a provision like that in colonies of the Spanish or Portuguese colonies. They were ruled directly from Madrid or Lisbon. But the English charters, Virginia and the other charters that followed, carried this language of privileges, franchises, and immunities. Now, one may fairly debate what the content of that was. You know, what exactly was that all about? But it meant basically when you left your home behind and went to this dangerous wilderness called Virginia or Massachusetts or wherever, you didn't leave your rights behind. They came with you. Now that is really implanted in the minds of colonists because those rights were guaranteed not only to the colonists, to the immigrants, but to their descendants down through the generations that followed. Now that planted a seed which really turned out to be pivotally important with the passage of time. Now the notion that English law mattered in America was reinforced by provisions that said when the colonial assemblies would pass ordinances or laws, they had to be compatible with the law of England. It was reinforced by provisions for the appeal of certain cases. Cases worth a certain amount of money could be appealed to the Privy Council or to some tribunal in London. So you had this constant reinfusion of English law. There are some interesting incidents that show how seriously the colonists took these promises of liberties and immunities. For example, in Massachusetts in the 17th century had an essentially theocratic form of government, and there were some dissidents who weren't very happy with that. They said, they actually filed a complaint. Robert Childs and some others said, "You're not giving us the rights of Magna Carta." Well, I'm sure the magistrates of the colony thought this was a bunch of hotheads and troublemakers and wished they'd just go away. but they felt obliged to reply to this complaint, and they produced what is called the Parallels of Massachusetts. And in it, you have in one column the provisions of Magna Carta, and in the other column, provisions of Massachusetts law. And obviously, this was an effort to persuade these dissidents that they were in fact enjoying the rights of Magna Carta. Now those Parallels of Massachusetts are probably an example of special pleading. You know, like any lawyer's brief will tend to put it in the most favorable light to that party. But what's important, I think, was that the rulers of the colony felt obliged to reply to the complaint and take it seriously and not just brush it aside. One other person that mattered in that period, William Penn, he was actually tried in London at one point before he actually settled Pennsylvania. The charge against him was, in effect, breach of the peace. And what it was really about was conducting a Quaker meeting without a license, without permission. It's a little hard for me to imagine a Quaker meeting being a breach of the peace, but basically an unlawful assembly. And in the trial, that trial has been recorded, and in it he pleaded Magna Carta repeatedly throughout the trial, including when the judge tried to domineer and browbeat the jury. And that case ultimately led to reinforcing the proposition that juries are entitled to return verdicts without being overborne by the judge. So Penn, in turn, as time passed, founded Pennsylvania, and the charter, the fundamental law of that charter was written by Penn, and in it, it includes, this is actually a charter for West New Jersey, which was a sister colony at that time. And in it, Penn put the provision that when the colonial legislature acted, when the local assembly passed laws, they could not be inconsistent with that fundamental charter. If they were, they'd be null and void. Now that's I think, building upon that medieval precedent of Magna Carta being better than ordinary laws. And you're students of the American constitutional system, you can see how this development is beginning to edge in the direction of Article 6 of the U.S. Constitution, the Supremacy Clause. We're not there yet, but it's clear that we're headed in that direction. Well, that was 17th century America. As you move into the 18th century, the flashpoint, as I'm sure you know from your own studies, the 7 Years' War as it was called in Europe, the French and Indian War, it was called in this country. Britain was victorious in the battlefield. They did much of the modern empire was based on those victories in the 7 Years' War. But it's like King John's adventures in France. These wars were expensive. A lot of debt was built up, and the British government decided, not unreasonably, that they had defended the American frontier against French and Indian attacks, and the Americans ought to help pay for it. This is a familiar story. So they passed the Stamp Act. Well, that was the first parliamentary measure that attempted to impose an internal tax in America. There'd been external customs duties and all that, but an internal tax was something new, and the colonists damn well didn't like it. They said, we won't have it, so there were resolutions and the like. This led finally to the Boston Tea Party, to the closing of the port of Boston, to quartering of troops on the citizens and the like. And that in turn, as you know, provoked the other colonies to come to the support of Massachusetts. They all rallied together, and when they met in the Continental Congress, they passed resolutions making America's case against British policy. And what fascinates me about this period is that the arguments are essentially constitutional. Take, if you will, for example, the arguments that James Otis made. This is 1761, famous case when he was arguing on behalf of merchants of Boston, the writs of assistance case. The case in which, it's sort of like our Fourth Amendment search and seizure, he was saying it's one thing to have a warrant naming the place and the things you're looking for, but these were open-ended general warrants that could be used anywhere, anytime, like a blank check. And he said, his argument was that is inconsistent with Magna Carta. So Otis was making what today would be called a constitutional argument, one which the British simply couldn't comprehend. Because Otis, in his case, cited Cook, Remember, I mentioned Coke and his role in the 17th century. Coke decided a case in 1610 called Dr. Bonham's case. And in it, he said that an act of Parliament against right reason was null and void. Now, historians have debated what that language really meant. It was dictum in his case. It was not the ratio decidendi of the case. But it certainly was taken by some people to mean that there were limits on Parliament's power. And that's precisely what Otis argued in Boston in the 1760s. Now, he was making a case which the British on the other side of the Atlantic couldn't understand, because by that point, Blackstone's commentaries had been written, and Blackstone said, you know, Parliament can do dumb things or crazy things, but Parliament calls the shots, right? Parliament is sovereign. It can do whatever it likes. Whether it's good or bad is something else, but in terms of constitutional power, Parliament has it. Well, now here's Blackstone on one side of the Atlantic and the Americans who'd read Coke on the other side of the Atlantic, and they're talking past each other. They're making constitutional arguments which simply do not meet. If you begin to realize just how fundamental the quarrel turned out to be between the colonists and the people over in England. So with the Continental Congress, they make arguments against British policy, and it's interesting to read those resolutions again. I don't know if those resolutions are part of the readings you all do this summer, but if you haven't read the resolutions of the 1774 Congress, it'd be worth taking a look at just to see how the arguments are framed. Because at that Congress, some people said, the question is, where do these rights we're claiming come from? What do we base them on? Well, some people said the British Constitution, Magna Carta. This is an ancient right guaranteed to us from time immemorial. Other people said, look, it's in the charters, like that Virginia language I quoted. We were assured that we would carry these rights as British subjects. Other people, especially from New England, said it's natural law. It's the will of God. It's natural right. And this really introduces a new level to the quarrel. If God gets involved in this dispute, that ups the ante a bit, I'd say. So they're talking about, okay, where are these rights? How do we articulate these rights? And what they finally did was sweep them all into one package. And basically say, you can call it natural law, you can call it charter rights, you can call it Magna Carta. It all adds up to the same thing. Namely, we have rights which you British are not respecting. And so, if any of you ever find this study of American constitutional law to be messy, a bit disorganized, we're not like the French. French love everything to be analytical and can, neat package and all that. It's very important. But the common law, they can't understand the common law. It's messy. It's not analytical. I would say you can't really understand American constitutional law unless you have some sense of the common law, because the reasoning is so much the same, precedents and evolving doctrines and the like. And it's analytically imprecise because we're willing to be eclectic. We're willing to take arguments from different sources, the way lawyers write a brief. You put in a procedural argument, substantive argument, constitutional argument, put them all in there. You just hope the judge will buy it. You want your client to win the case, right? And you may care intellectually about which one of these arguments is the best, but if the judge will buy one of them, you're home free, right? And your client is happy. This is the way American constitutional law is, I think, very much influenced. Well, so you've got this turbulent period, and as you know, these constitutional arguments were not decided until the Revolution broke out and the victory was obtained at Yorktown. So what we pass now into the period where Americans begin writing constitutions. And now this is new territory, because this takes you in many ways beyond Magna Carta. Excuse me. In Williamsburg in May of 1776, the same body of men that instructed Virginia's delegates in Congress to introduce the Declaration and the Resolution for Independence on the same day set to work on the first Virginia Constitution. Not the one I worked on, by the way. It was a little bit before my time again. Actually, they went to work on two documents. I think this is interesting, because first they wrote a Declaration of Rights. Then they wrote a frame of government. And what they were basically, this is pure John Locke. This is social compact. They're saying the first thing you do is you set down your rights. You make it clear what those rights are, and then you move on to the business of erecting a frame of government, because you've made it clear that these rights pre-exist government. They're natural rights. This is, I think, again, very distinctive. Well, this was an interesting period. It was sort of a mix of British doctrine with Locke and social compact, natural law. But it disappointed Thomas Jefferson. Jefferson was in Philadelphia. He was not in Williamsburg. He spent the next 50 years complaining about this first Virginia Constitution. Now, I never met Thomas Jefferson, but I suspect one thing that troubled him was he couldn't imagine you could do a complete job without him being there. Right? He just said, you can't do it without me. But his argument against that first Constitution was that it was passed by the same body of men who were passing ordinary laws. He says that confuses two functions. It means that the Constitution is just another law. And it needs to be put on a plane higher than ordinary law. But Virginia didn't do that. It was all on the one plane. Well, what we didn't do here, I'm going to give credit. I've been beating up on my friends in Massachusetts. Let me give some credit. I want you to pay attention to this, because I'm a parochial Virginian. I don't go around saying nice things about other states. But this is where Massachusetts did something Virginia did not conceive of, and that is, when it came time that they worked on their first Constitution, I think they call it the General Court in Massachusetts, what we would call the General Assembly in Virginia. They were going to write a Constitution, but the people in the western part of the state, they're called the Berkshire Constitutionalists, wouldn't have it, because they thought the rich people in Boston were going to put one over on them. In the west part of the states were the debtors and the poor farmers and all that, and the mortgages were all held by people in Boston. And they said, no, we're not going to have a Constitution written by the General Court. We insist on your electing delegates to a convention to write a Constitution. So Massachusetts did that. They elected delegates, convention wrote a Constitution. Here's where John Adams comes to the fore. There were, in the body of delegates in Boston, they delegated the actual drafting process to a committee of three people: John Adams, Samuel Bowdoin. And Bowdoin and Samuel Adams basically handed the work over to John Adams. And they went off to a tavern or something like that. And John Adams, being the workhorse that he was, said, okay, I'll do it. And he did. He basically wrote the Massachusetts Constitution. Go into a pub in Georgetown sometime and ask for a John Adams beer. You're going to get a blank look, right? The bartender will say, ask for a Samuel Adams beer. He knows what you're talking about. You'll get one of those. So there's the difference, I think, between the two Adamses. Each left his mark on history. So they wrote the Constitution. It was then voted on by the people in referendum. This is one of the most remarkable moments in constitutional history. America had invented something the Europeans had not conceived, namely the idea of the Constitutional Convention, elected for the express purpose of writing a constitution, and then giving its product to the people for popular vote. And that became a model for other states. So you have a real threshold there in Massachusetts in 1780. Next chapter in the story is the federal Constitution and Bill of Rights. Now we're into the Madisonian era, obviously, as you all know about the road from Madison's Virginia plan to Philadelphia and finally to the Bill of Rights and ratification. This is new ground, because whatever Magna Carta was about, it was really a power struggle between barons and the king. It was not designed to create a new form of government. In fact, the purpose of it in part was to sort of reaffirm old existing principles. And so at Philadelphia, they were doing something new that the British had not had to do. The Federalists also, it's interesting, I'm not aware that Magna Carta was ever mentioned at the Federal Convention in 1787. Now, as you know, we don't have a complete transcript. We've got Madison's notes. which comprised maybe, 10% of what was actually said on the floor. So Magna Carta could have been mentioned, but it was not, as far as I know. And I think the reason was, I mean, and that's kind of interesting that here the Americans have spent all this time invoking Magna Carta against the British, and then comes time to write a constitution. Where's Magna Carta? Well, I think the Federalist understanding was, in the first place, Magna Carta was meant to be a limit on the king, a limit on royal power, whereas the Constitution was meant to be a limit on all the branches of government, legislative, judicial, and executive. I think that was one difference, and I think another difference the Federalists conceived was that Magna Carta was in effect a grant from the king, a concession on the part of the king, whereas the Constitution was founded on the will of the people, popular sovereignty. And so given all those differences, as you know, the Federalists stumbled at this point, an almost fatal mistake. They rejected the proposal at Philadelphia for a Bill of Rights. Familiar story. Well, as you know, when the Constitution went out for ratification, the anti-Federalists had a ready argument. No Bill of Rights. They're taking our rights away from them. And James Madison, who at first thought a Bill of Rights was not only unnecessary, but maybe even dangerous, was persuaded, I think, by Jefferson to finally come around on it and say, okay, we get it, just ratify the Constitution, and at the first Congress we'll propose a Bill of Rights. And of course, he was as good as his word, filtered out the various proposals from the states, and we got our Bill of Rights. So what's the story amount to? If you put together the Magna Carta side of it and put together the American contributions to it, you get a blend of tradition on the one hand and innovation on the other. Judicial review would be an example of the innovation side, not something the British then or now have devised. Judges in the UK still don't have the power to strike down an act of parliament as being unconstitutional. And judicial review remained on the world scene exceptional until after World War II. I mean, as of 1945, very few high courts in any country in the world had that power, but it's now, I'd say, a majority of the written constitutions of at least countries that are liberal democracies. A majority of those constitutions have explicit guarantees of the power of judicial review. So you've got innovations on the American side. Federalism, I would say, was another one, but you have tradition embodied in Magna Carta. So to sum up the legacy of Magna Carta, what would we say Magna Carta stands for in American constitutionalism? First and foremost, and this is probably the most pervasive, iconic reflection of Magna Carta, and that is the notion of rule of law. Familiar phrase, lawyers love to talk about it all the time, as if it were self-explanatory. It actually takes a little bit of teasing. I was in what was then Leningrad, now St. Petersburg, working with the drafters of the first post-communist constitution. This was back in that brief moment when it looked like Russia might become one of the community of liberal constitutional democracies. Boy, it seems like a long time ago, doesn't it? I mean, it's hard to remember that ever was even conceived possible in the age of Putin. But I remember being at the table, and I don't speak any Russian, so we were working through a translator. And there was this woman, very good translator, doing a wonderful job. But I discovered at one point that she was rendering the English language phrase rule of law as socialist legality. Well, I had to say, no, that's not exactly, that's not quite what we're talking about when we talk about rule of law. Second part of the legacy, I think, is the articulation, reaffirmation of the idea of fundamental right, that pervasive in Anglo-American constitutional culture, Magna Carta, Petition of Right, English Bill of Rights, U.S. Constitution, U.S. Bill of Rights, and on, is the notion that rights are very much at the core of the enterprise. Thirdly, I think the very idea of a written constitution, the idea of putting it down in writing. I mean, Magna Carta is, again, the iconic example of a written document reflecting a constitutional settlement, and it's a long Anglo-American tradition. Fourthly, I think, and I've anticipated this point, Magna Carta and its uses, its glosses, its interpretations, they anticipate the notion of constitutional supremacy. The sort of notion Jefferson's complained about the Virginia Constitution, what Massachusetts was able to achieve. I think going all the way back to that English statute that said you should prefer Magna Carta to ordinary laws. It goes back to Dr. Bonham's case, Cook's decision in 1610, goes back to James Otis's argument in Boston. It's a long road, but it finally leads to the point of saying constitutions are not ordinary laws. They must be seen as super statutes. It's almost as if it becomes self-fulfilling. Think about the first time you ever read Marbury versus Madison. If this were my classroom, I could cold call one of you right now, couldn't I? But I won't do that. I'm not going to say recite Marbury versus Madison. But do you remember when you read the opinion that Marshall begins with talking about general principles of jurisprudence? The idea of what is a constitution all about? What is the idea of a constitution? He talks about that. He then moves on. Finally, late in the opinion, almost as if it's an afterthought, he says, oh yes, and by the way, there's the language of Article 6, the supremacy clause. I mean, today a judge would surely start with the text of the Constitution and then move on to other arguments. But Marshall, I think, is presenting the question as if it's a self-evident proposition. You write a Constitution, of course you mean for it to be superior, and that is reflected in the supremacy clause. But it's as if he couldn't imagine it coming out any other way. Fifthly, another legacy of Magna Carta is the notion of organic, unfolding, evolving constitutional doctrine. And here, once again, constitutional law is rather like common law. I mean, think about something like I mentioned cruel and unusual punishment. In 1989, the Supreme Court decided 2 Eighth Amendment cases, capital punishment cases, and one had to do with whether it was constitutional to execute a defendant who was somewhat mentally retarded, and the other had to do with executing a very youthful offender, say 15 years old. 1989, the split court, rejected the argument that those 2 practices were violations of the Eighth Amendment. Within the next 2 decades, in the early part of the 21st century, the court overruled each of those opinions, overruled its own fairly recent cases. The notion now that what had been the dissenters now had the majority to say it is cruel and unusual punishment to execute defendants under those circumstances. It's a classic example of the evolving notion of what cruel and unusual punishment is all about. Perhaps an even more, equally as clear, but certainly more pervasive example is the uses of due process of law. I mean, think of the pages that have been written, the scholarship that's been produced, the debates that have taken place over what do you mean by due process of law? Is there such a thing as substantive due process? Is that a perversion of the judicial process? You're all familiar with the pages of the U.S. Supreme Court opinions that rehearse these arguments. Take, if you will, I'm going to quote language from one of Justice Kennedy's opinions. Lawrence versus Texas, 2003, the case where the court struck down Texas's anti-sodomy law. And here's what Kennedy said. He said, those who drew and ratified the Due Process Clause did not presume to know the components of liberty in its manifold possibilities. The times can blind us to certain truths, and later generations can see that laws once thought necessary and proper serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Now that's a clear, I think, simple, straightforward statement of the notion of the evolving Constitution. And if you have read the recent same-sex marriage opinion, Justice Kennedy, once again speaking for the majority, used language almost word for word. He didn't actually quote Lawrence versus Texas. It's almost as if it were right up there in his mind. He didn't have to quote it. He said, this is my way of thinking about the Constitution. Now, as you know, this is a very controversial proposition. Those who don't like it label it the living Constitution, and by that they don't intend a compliment when they use it. So you know, I'm glad Justice Scalia is not here in the room. He would be gagging at this point on hearing me even using that phrase. So I think that may be the most remarkable and striking, most pervasive legacy of Magna Carta is that notion of the organic Constitution. One last thing before I wrap it up, and that is to go back to where I started and a word about Magna Carta itself. I mentioned that copies were knocked off by scribes and sent out to different counties in England. 4 copies survive of the 1215 Charter, 2 in the British Library, 1 in Lincoln Cathedral, 1 in Salisbury Cathedral. They're within the reissues, so altogether, if you count all the extant copies from 1215 to 1297, there are 17 extant copies. They're all in England, except for 1 in Australia and 1 here at the National Archives. I was on an airplane one time flying to London, and it happened to be that my seatmate turned out to be a lawyer who represented Ross Perot. And he told me the story of how he was, Ross Perot, who heard that there was a copy of Magna Carta owned by a private family in England. And I guess Ross Perot had everything else you could imagine a person of wealth having. He said, I think I'd like to have a copy of Magna Carta. So he sends this lawyer over to England who bargains for, this is back in the 1980s, bargains for the purchase of this, it's 1297 copy for $1.5 million. He gets it back, and of course I had questions, well, you know, this is a, you know, important document. Don't the British have laws about exporting their patrimony and all that? I'm sure he jumped through all the right hoops, but he said, well, he went to Heathrow Airport. He took this copy of Magna Carta, rolled it up, and put it in a mailing tube. I was thinking, it's a 13th century document in a mailing tube. And the customs agent asked him, what do you have in the tube? And he said, I have a copy of Magna Carta. Right, mate, go around through it. So, copy of Magna Carta, well, facsimile, perhaps. So he got it home, it went on display, time passed, and I guess Ross Perot decided he didn't really need this copy of Magna Carta anymore, decided to sell it. It went on auction in New York, up at Sotheby's, and David Rubenstein, another man of some millions, heard about it, bid for this copy of Magna Carta over the telephone, paid $21.5 million for it. Okay, 1.5 to 21.5. No wonder Ross Perot's got money. I mean, that's quite a nice bargain. So the National Archives called me and said, we're going to have a ceremony putting this copy of Magna Carta on display, and would I come and give a talk? And I said, I'd be happy to do that. So the Washington Post, I think on Thursdays, has a little box. They pick out 3 or 4 things that are sort of interesting the next week that you might like to know about, you might want to go hear. And the week before my talk at the archives, they had this little notice that said, Professor A.E. Dick Howard of the University of Virginia on March the 10th at 7:30 p.m. or whatever, will be at the National Archives to talk about his book, The Road from Runnymede, and his purchase of Magna Carta for $21.5 million. Well, I came home that night, I said to my wife, I said, Mary, we're going to start getting some very interesting phone calls. People are going to be inviting us to some very fancy dinners and parties. I said, don't ask any questions, just say yes to that. So that was my moment of glory. I think most people read that. They knew it couldn't be so. No law professor's got that kind of money. So now you know a little bit about Magna Carta, what it meant, I'd like to think, in American law. We don't live in feudal times. We're not worried, I think, about the pretensions of monarchs. But it does seem to me that we are pursuing, in the shadow of James Madison and the other founders, that we're pursuing a search for ordered liberty very much in the way that traces back to the meadow at Runnymede itself. So thank you very much.